as it was outlined also by Professor Chubik, who sent us his research beforehand, and it served as very good inspiration for my own research. This topic of recognition of foreign documents is highly relevant in the globalized world. In the past few decades, we've seen an acceleration of cross-border movement of people, of capital, goods, services. And for legal professionals, this means that almost every case now involves some foreign element, a power of attorney signed in New York, a birth certificate from Berlin, or a court judgment from London. So in Hungary, the recognition of these documents is the intersection of strict procedural formalism and with the rise of digitalization. So the Hungarian system operates under two main pillars. First, you have the general rules within the Code of Civil Procedure, and of course, I talk about the use of civil documents more. And this piece of legislation handles how evidence is admitted, and the Act on Private International Law, which governs the validity of the legal acts themselves. So in my presentation, I will basically present some of the rules pertaining to authentication, and then briefly address matters of translation, and then matters of private international law briefly. So I will jump right in here by presenting something that I think is quite familiar to all of our colleagues here, which is the hierarchy of authentication. So when you hold a foreign document, your first task is to identify which lane of authentication it belongs to. Hungarian law follows this strict hierarchy where international treaties and EU norms take precedence over domestic rules. So this might be very familiar to you all. This, I have to note here that Hungarian law does not actually define the term document for the purposes of civil court proceedings, which actually makes the applicable rules timeless in terms of technological development. The general Hungarian regulation contained in the Code of Civil Procedure essentially requires that a document maintain its utility in Hungary, which is served by the institutions of superlegalization and recognition. It is widely admitted that there are certain general steps that must be followed when recognizing a foreign document. First, it should be analyzed whether there are diplomatic relations between the country of issuance and Hungary, or Hungary and the country of use. The international circulation of documents is based on recognition, and recognition in turn is based on agreements and actions of so-called trusted institutions. So if there are diplomatic relations between two countries, this forms the basis for all other actions and agreements, as diplomatic officials are the recognized persons of trust. Next, it's important to identify the depth of these diplomatic relations, whether there are any international agreements between the country of use and the country of issuance that facilitates recognition, be these bilateral relations or plurilateral ones, and also the extent to which these rules, these lex specialis rules, facilitate recognition. Finally, it must be determined whether the document is a public or a private document, as this determines which rules will apply to the document, to what extent it can be considered authentic, and whether further official procedures such as authentication or legalization are necessary in the country of issuance or within Hungary for their use internationally. So accordingly, as a first lane, you have to check for bilateral legal assistance treaties, and Hungary has such treaties with over 30 nations, including France, Austria, China, or Russia. In these cases, a document with a valid signature and seal is often accepted as is, with no further legalization required. Of course, you have the EU lane, which is for our colleagues from EU member state countries quite familiar. So you might have certain regulations that would apply in between EU member states, such as the with regard to documents pertaining to civil status, birth or marriage certificates. These are now part of a system where you have multilingual forms that bypass the need for both legalization and translation. Then you have the so-called apostille lane, which is, of course, a plurilateral treaty with over 128 members. And then finally, as a last resort, you have the diplomatic lane, which is also, I would call it the slow lane for non-Hague or non-treaty states. This requires a chain of certifications that usually end at the Hungarian consul. Conversely, if someone does it the other way around, so from my slides, you would see from 4 towards 1, if someone starts out within the diplomatic lane, then they would be covered for all the rest, right? Because that's the most general way of having a document recognized. So if you take the diplomatic lane first, then you cannot be obliged to undertake in any further actions that may be provided for in an applicable treaty, such as the a bilateral treaty. Finally, of course, without proper authentication, a foreign public document loses its qualified evidentiary weight and may be treated as a simple private document or outright ignored by courts and administrative institutions. On this red slide, you will note the basic rule coming out of the Hungarian Code of Civil Procedure. So there are several details herein that don't really translate well into an oral presentation because it's just way too much detail for anyone to comprehend. But I have them jotted down in my own chapter, so I invite you to see that. I will just note a couple of brief details. So the Hungarian Code of Civil Procedure regards a document as being a public document when it is a paper-based or electronic document issued by a court, a notary, or other authority within its scope of responsibilities and in the form prescribed by law. As a general rule, a public document proves with full probative value that the issuing entity carried out the measure or decision contained within it, that the data and facts contained in the document are true, and that the statement contained was made at the indicated place at the indicated time. Then there's different section in the Hungarian Code of Civil Procedure, which basically sends us to these rules when it comes to their application on foreign public documents. So if the foreign public document was legalized by a competent Hungarian diplomatic mission at the place of issuance, unless a different requirement is specified in an international agreement entered into with the country in which it was issued, it should be recognized as a foreign document. Consequently, the general rule with regards to foreign public documents contains a default requirement for diplomatic legalization for it to enjoy the evidentiary weight of a public document in front of Hungarian authorities. Without this super legalization or authentication, foreign public document is to be considered merely a private document or maybe disregarded entirely, depending on the strictness of the proceedings. In the legal literature, which I found to be very scarce and dominated actually by in the Hungarian legal literature is dominated actually by practitioners. So I found a comprehensive book written by notaries public, which was very useful for the purposes of this research. So in this legal literature, it was retained that from the perspective of Hungarian authorities, a public document qualifies as such if it meets the definition that is set forth in the Hungarian Code of Civil Procedure. And this classification extends to foreign documents that are issued by a diplomatic or administrative authority of the respective country, acting within its official scope of authority and assuming responsibility in that capacity, that have a public document character, which is declared through intermediate or superlegalization, and which are thereby recognized through established diplomatic or international channels for their use in Hungary, provided that they do not violate public policy, evidently. Now, of course, the diplomatic legalization is not a strict requirement. It rather acts as the baseline, and any derogation from it via domestic law or international agreements will apply accordingly. There are other legal provisions which appear to be more lenient, such as the Code of Administrative Procedure, which provides that foreign public documents generally have probative value, and legalization is only required if there are doubts as to the authenticity or the contents of the document. In a private, when it comes to foreign private documents, a private document will, with the Hungarian law makes a difference between two types of foreign private documents. You have simple private documents and then private documents with full probative force. So a private document with full probative force, until proven otherwise, proves the full probative value that the signatory to the document has made, accepted, or acknowledged as binding upon him or herself in the statement contained therein. The conditions for a document to have full probative force are set out extensively in the Hungarian Code of Civil Proceedings, Civil Procedure, with criteria such as the document having been written and signed by hand by the issuer, or the certification of the signature of the issuer by two witnesses. So there's at least 7 or 10 such conditions. They are not cumulative conditions. It's either one of those is met, then the document is considered to be a private document that has full probative force. A private document that has full probative value retains this status, and its authenticity will only have to be proven if the opposing party or if the court deems it necessary. So, of course, this means that if there's an opposing party, they will likely ask for clarifications, require authentication, because at least it prolongs the proceedings. But of course, I guess as a practicing attorney would say, I would definitely ask for authentication because I'm not going to risk the document not being authentic or containing false information. There's also, in terms of private documents, these are not subject to any type of a legal presumption, meaning that their probative value is to be determined by the court in accordance with the general rules of evidence and taking into account the facts of the case and the presented evidence, unless there's some type of different regulation that would apply to them as lex specialis. So in terms of legalization and apostille, I think the rules are quite similar. So I will now jump to the matter of translations. So in Hungary, obviously, the official language is Hungarian. So the question of translation will surely arise in the cross-border use of documents. Public institutions exclusively use the Hungarian language. So if a document is in a foreign language, you generally must provide a translation. But of course, not all translations are equal. Diplomatic legislation or diplomatic legalization and apostille certification are issued for public documents. However, in Hungary, a public document and the translation of a public document have always been treated somewhat separately. So in what way? Well, certified translation of a public document, while not in itself a public document, enjoys some of the advantages of the public document that it reflects. Namely, that it can be legalized and the translation is assumed to be correct. But it is not only certified translations that can be used, simple translations may also be acceptable. This is so because the Hungarian Code of Civil Procedure only provides that in the case of reliance on documents in a foreign language, a simple Hungarian translation must be attached to the submission. So not attaching a translation may result in the rejection of the submission, but a certified translation is only mandated if there's any doubt as to the accuracy of the contents of the translated document. In Hungary, there is a state-controlled monopoly on certified translations, which is held by the Hungarian Office for Translation and Attestation, the so-called OFFI, OFFI. I think today it's called MKIFK, abbreviations, no one, it doesn't really matter, but the fact is the same, that it's a centralized system. It's a government-run office where you take translations, they take foreign documents to be translated. So almost all official court and administrative proceedings, when they require a certified translation, they will require a so-called OFFI stamp. One notable exception is the translation of company documents for registration. But other than that, I've provided in my publication an extensive list of or at least a reference to an extensive list of legal provisions that require certified translation at OFFI, and it's a very long list. It's like a 20-page list of legal provisions. This monopoly is actually currently in a flashpoint. There was, in the December infringements package from the European Commission, infringement proceedings were lodged against Hungary, arguing that this exclusive right violates the EU freedom to provide services. So we'll see what will happen, but it's likely that this monopoly will be attempted to be broken up by the European Commission. Finally, in terms of private international law, so once the document is admitted as evidence in the Hungarian system and the probative value is established, the analysis shifts to the formal validity of the legal act that it records. And so this is more or less the same as I've heard from the other colleagues. There is this basic principle of favor negoti. So the Hungarian legal system very much attempts to save or maintain the validity of a document. The general rule in terms of documents is contained in Section 54 of the Hungarian Private International Law Act. And the basic general rule is the lex cause rule and or the lex loci contractus or lex loci actus rule. And then you have the exception that we've previously also heard about, which pertains to, well, the most important exception, which pertains to the sale or contractual relations having to do with immovable property. So I think I will stop there because I think I'm at the end of my time. And yeah, I look forward to taking this project to its end. Thank you for allowing me to be here.